So what is the statute of limitations for a car accident case in Florida? Hi, my name is Charles Bust and I'm a personal injury and wrongful death attorney in Orlando, Florida. And today we're going to be talking about the legal deadline for filing a car accident lawsuit in Florida. So let's get started. So what is the statute of limitations? The statute of limitations is basically a legal deadline, and it typically starts on the day when you get hurt. Thus, in a car accident case, the statute of limitations is typically measured from the day of the crash. And in Florida, the statute of limitations for personal injury cases is 4 years. So, if you've been in a car accident in Florida, you have 4 years to file your car accident case. Now, if you don't file your lawsuit within the 4 years and the statute of limitations runs out, you lose your right to file a lawsuit. Now, it's important to point out that the statute of limitations can be different in different states, depending on the laws of that state. Now, as we talked about, the statute of limitations for personal injury cases in Florida is 4 years. However, if the car accident occurred in South Carolina or North Carolina, the statute of limitations is 3 years. And if the same accident occurred in Georgia or Alabama, the statute of limitations is 2 years. And in Tennessee, the statute of limitations is only 1 year. So, where your accident occurred is critical in determining how long you have to file your car accident lawsuit. It's also important to note that in different types of cases, the statute of limitations may be shorter or longer. Now, as we talked about, personal injury cases must be brought within 4 years in Florida. And this includes things like car accidents, semi-truck accidents, pedestrian accidents, slip and falls, amusement park accidents, and bicycle accidents. However, the statute of limitations may be shorter for wrongful death cases as well as cases based on medical negligence, and that's the case in Florida. So let's talk about wrongful death cases for a minute. In Florida, the statute of limitations for wrongful death cases is 2 years from the day the person died. So just to clarify, wrongful death cases are essentially personal injury claims that are brought on behalf of someone who was killed as a result of negligence, as opposed to the typical personal injury case where a person gets injured rather than killed. So these cases are typically brought by the personal representative of the decedent's estate. Therefore, if someone died as a result of a car crash in Florida, the person filing the wrongful death suit, which is typically the personal representative, will have 2 years to file that lawsuit. Another category of cases with a shorter statute of limitations in Florida is medical malpractice cases. So in Florida, the statute of limitations for medical malpractice cases is 2 years. And the same is true for dental malpractice cases or any other cases based on medical negligence. And this includes cases where a person is injured or killed by medical negligence, a wrongful death medical malpractice case. So in Florida, that 2-year clock may start running from the day of the incident, or it may start running from the date the victim discovered his or her injuries, or reasonably should have discovered those injuries. However, regardless of when the victim discovers the injuries, medical malpractice cases may not be brought more than 4 years after the date of the incident in Florida. Well, that's all I have for you today. If you have any questions at all about your personal injury or wrongful death case, please don't hesitate to give us a call. We're happy to give you a free legal consultation, which means a phone call is completely risk-free for you. All you have to do is call us at the number below in the video description, or you can look us up at www.carelessdriver.com. Thank you so much for watching this video, and we'll see you next time.